In 1996, a family of doctors and businessmen launched a pill onto the American market. Over the following 20 years, that pill killed more than 450,000 people. The family walked away with over $10 billion. And not one of its members spent a single day in prison. This is not a case of negligence. It is not an accidental tragedy. It is the detailed blueprint of how a private corporation can hijack a healthcare system, corrupt regulators, manipulate doctors, and weaponize science itself, all while money flowed into offshore accounts shielded by untouchable trusts. And when the government finally acted, what it found was not a company that had escaped accountability. It found a company that had committed the same crimes twice and had planned every step of its impunity with the same precision it had used to plan the crime. If this kind of story interests you, subscribe to the channel and hit the bell. And tell me in the comments, did you know that a company can plead guilty to federal crimes, pay a fine, and continue operating normally for another decade? The Sackler family bought Purdue Pharma in 1952. The company had existed since 1892, founded as the Purdue Frederick Company by John Purdue Gray, a modest pharmaceutical business with nothing particularly distinctive about it. When Arthur, Mortimer, and Raymond Sackler signed the purchase agreement, it was a small operation focused on niche products. The three brothers were physicians. They knew exactly how the American healthcare system worked from the inside. Arthur Sackler died in 1987, before the product that would define the family's legacy even existed. His stake passed to his brothers. Mortimer and Raymond guided the company through its decisive transition. In 1991, they incorporated the modern Purdue Pharma LP, headquartered in Stamford, Connecticut, with a clear focus: pain management drugs. The backdrop matters. During the 1980s and early 1990s, there was growing pressure within American medicine to treat chronic pain more aggressively. The dominant narrative held that doctors had an unnecessary fear of prescribing opioids, that patients were suffering needlessly, and that a new generation of medications could solve that problem safely. That narrative did not arise spontaneously. It was funded, cultivated, and amplified by pharmaceutical companies, and Purdue was the most systematic of all in that effort. In 1984, the company launched OxyContin, an extended-release formulation of morphine. It was the dress rehearsal. The slow-release technology was presented as a safer solution. The drug dissolved gradually, which Purdue claimed would reduce the potential for abuse. It was an argument that sounded convincing, and the company already knew at that point where that argument had holes. The logic was simple and deadly. If the release is slow, the euphoric effect is smaller. Therefore, the risk of addiction is smaller. Purdue turned that incomplete logic into a marketing dogma. And when the time came to launch OxyContin in 1996, the machinery was already in place. Curtis Wright was an FDA employee, the American Drug Regulatory Agency. He was the one who approved OxyContin with a label containing an extraordinary claim: the drug would be less subject to abuse than other alternatives due to its extended-release properties. That claim had no solid scientific basis. It was a hypothesis, presented as regulatory fact. Shortly after approving the drug, Curtis Wright was hired by Purdue Pharma. In its first year, OxyContin sales reached $48 million. By 2000, less than 4 years after launch, they had climbed to nearly $1.1 billion. The speed of that growth was no accident. It was engineering. Purdue hired McKinsey and Company to design and implement its marketing strategies. The world's most prestigious consulting firm was formally involved in expanding sales of an opioid. Internal documents later revealed show exactly what was built: an incentive system where sales representatives received bonuses of up to $240,000 for hitting prescription targets. Not targets for treating patients with severe pain. Volume targets for prescriptions written. Purdue identified high-volume prescribers, doctors who signed a large number of prescriptions, and turned them into priority targets. Sales representatives made repeated visits, armed with data on each doctor's prescribing habits, tailoring their pitch to maximize results. One doctor in Kentucky was known among patients as the Candy Man. He prescribed, in the words of an internal Purdue document, crazy doses of OxyContin. The company sent sales representatives to meet with him more than 300 times. And while all of this was happening in the streets and in doctors' offices, Purdue was building its scientific credibility from the inside out. Russell Portenoy was chair of the Department of Pain Medicine and Palliative Care at Beth Israel Hospital in New York. He was one of the most respected physicians in the country in the field of pain management. Purdue and other pharmaceutical companies paid large sums of money to Portenoy and his department. He became one of the most influential advocates for the thesis that prescribed opioids were safe for chronic, non-cancer pain. That thesis was incorporated into clinical guidelines, medical training, and academic papers. The company also funded the American Pain Society and the International Association for the Study of Pain, organizations that consulted with the World Health Organization on global pain treatment guidelines. Purdue's influence was not contained within American borders. It attempted to export the model. In 1997, approximately 670,000 OxyContin prescriptions were issued for less severe pain, conditions that would not normally justify a powerful opioid. By 2002, that number had jumped to 6.2 million prescriptions, a nearly tenfold increase in 5 years. But that figure conceals something more serious. What was growing was not just use, it was addiction. And Purdue knew it. Internal documents obtained during legal proceedings show that company executives were well aware of OxyContin's abuse potential from the earliest years. In 1994, 2 years before the launch, executive Michael Friedman sent an email to 3 members of the Sackler family proposing to expand OxyContin's use beyond cancer patients. The conversation about non-oncological pain, the vastly larger market, was already happening internally before the product had even been approved. The company instructed its sales representatives to tell doctors that OxyContin was not addictive because of its slow-release properties. When a doctor questioned the abuse reports that were beginning to surface, the response was standardized. Only people with an addictive personality became dependent. Responsibility was shifted to the patient. The fault lay with the user, never with the product. In 1998, Purdue finalized long-term supply agreements with Johnson & Johnson companies for raw materials for its opioid products. The supply chain was integrated. The business model was robust, and the Sacklers continued to expand the operation. In 2013, family members approved a program called Evolve to Excellence. The name sounds like a quality improvement initiative. In practice, it was a plan to intensify marketing to high-volume prescribers and promote higher doses of OxyContin. The family was directly involved in the company's strategic decisions. They were not passive shareholders. They were active operators of a system that continued to kill. But what happened next revealed the most calculated dimension of this entire story. In May 2007, Purdue Pharma pleaded guilty to misleading the public about OxyContin's addiction risk. The company admitted that it had marketed the drug as less addictive, less subject to abuse, and less likely to cause withdrawal symptoms than competing medications. It paid more than $600 million, one of the largest pharmaceutical settlements in American history up to that point. The company's president, Michael Friedman, its chief legal officer, Howard R. Udell, and its former chief medical officer, Paul D. Goldenheim, also individually pleaded guilty to charges of misbranding. Together, they paid $34.5 million in fines. They were sentenced to 400 hours of community service at drug treatment programs. Not one of them spent a single day in prison. The system had absorbed the corporate guilt, processed the paperwork, signed the checks, and moved on. And Purdue Pharma moved on too, committing the same crimes. The company formally admitted that 13 years later. Between May 2007 and at least March 2017, that is, for an entire decade after pleading guilty the first time, Purdue conspired to defraud the United States by obstructing the lawful operation of the DEA. It reported to the agency that it maintained an effective program to combat drug diversion. In reality, it continued to market its products to more than 100 healthcare providers whom the company had concrete reasons to believe were diverting opioids into the illegal market. It reported false data to the DEA to increase its manufacturing quotas, including prescription data written by doctors the company knew were involved in diversion. Between June 2009 and March 2017, Purdue made payments to 2 physicians through its speaker program to induce them to write more prescriptions. These were not real speaking engagements. It was kickback money structured within an institutional format. And in 2016, the operation reached a level of sophistication that deserves special attention. Practice Fusion was an electronic health records company based in San Francisco, used by approximately 32,000 medical practices across the United States to manage tens of millions of patient records. It was critical infrastructure within the American healthcare system. Between April and December 2016, Purdue paid Practice Fusion nearly $1 million to create clinical decision support alerts, notifications that appeared on a doctor's screen during patient visits, suggesting therapeutic courses of action. These alerts were presented to doctors as impartial clinical recommendations based on scientific evidence. In reality, they were part of an illegal marketing scheme. Purdue's internal marketing documents described the program's key performance indicator in a single phrase: increase in long-acting opioid prescriptions. Data compiled by the Department of Justice showed that doctors who saw these alerts reversed the declining trend in their prescribing and began writing more opioid prescriptions, sometimes for patients who did not need them. Purdue did not merely corrupt doctors, it corrupted the very software doctors used to make decisions. It infiltrated the digital architecture of the healthcare system to turn every patient visit into a sales opportunity. Meanwhile, money was flowing out of the company at an accelerating pace. Between 2008 and 2018, the Sackler family withdrew more than $10 billion from Purdue. The payments, which totaled approximately $10.7 billion, were deposited primarily into offshore accounts and trusts, deliberately structured to remain beyond the reach of American creditors. Bankruptcy proceeding documents show that these transfers were made at the Sacklers' own request, as part of a strategy to shield assets from future creditors, which constitutes, under American law, fraudulent transfer of assets. The company generated more than $35 billion in revenue since OxyContin's launch. The family was, according to Forbes, one of the 15 wealthiest families in the United States, wealthier than the Rockefellers, with an estimated net worth of $13 billion. The Sacklers were also major philanthropists. Their names adorned galleries, museums, and universities: the Sackler Gallery at the Smithsonian, the Sackler Museum at Harvard, endowed chairs at Yale, NYU, the Met, and the Guggenheim. All of that philanthropy was built on 450,000 deaths. In September 2019, Purdue Pharma filed for Chapter 11 bankruptcy protection in New York. It was the move the family's lawyers had planned. The bankruptcy would function as a containment mechanism. It would consolidate all lawsuits into a single judicial forum, cap the total value of settlements, and, in the original proposal, grant members of the Sackler family immunity from future civil suits in exchange for a financial contribution, with no admission of wrongdoing. In October 2020, the Department of Justice announced a global resolution. Purdue pleaded guilty to all 3 federal criminal charges. The total settlement exceeded $8 billion, including a criminal fine of $3.5 billion, an additional $2 billion in forfeiture, and a civil settlement of $2.8 billion. The Sackler family, separately, paid $225 million to resolve its civil liability. No family member was criminally indicted. None admitted any wrongdoing. In December 2020, Sackler family members testified publicly under oath before the United States Congress for the first time. Cathay Sackler, who had served as vice president and board member of Purdue for nearly 20 years, said under oath, "I find nothing I would have done differently." David Sackler, who served on the board between 2012 and 2018, declared, "The family and the board acted legally and ethically." Committee chairwoman Carolyn B. Maloney presented documents showing how family members had pressured executives to expand OxyContin's market share, target high-volume prescribers, and promote higher doses. Documents that proved direct involvement in the decisions that fueled the epidemic. The question was no longer whether the family had known. It was whether any institutional system would have enough force to hold them accountable. The answer came in stages, and each stage revealed the limits of that system. Judge Colleen McMahon of the United States District Court for the Southern District of New York ruled in December 2021 that the original bankruptcy agreement should not proceed because it released the Sackler family from future civil liability, a mechanism the judge found improper. In March 2022, a new agreement was proposed, up to $6 billion from the Sackler family in exchange for immunity. Several state attorneys general opposed it. The judge rejected the agreement, citing the excessive protections granted to the family. The legal disputes dragged on for years. The criminal sentence, which should have been handed down shortly after the guilty plea in 2020, did not come until April 29, 2026, in Newark, New Jersey. Purdue paid $225 million to the Department of Justice as part of the criminal agreement. The bankruptcy settlement of approximately $7.4 billion directs the bulk of the funds toward substance use disorder treatment programs across the United States. The company ceased to exist in its original form. It was replaced by Knoa Pharma, with a board appointed by the states and a mandate to combat the opioid crisis, created using the assets of the same company that built that crisis. Before sentencing, Assistant Attorney General Tyson Duva told reporters that Purdue's conduct, which had devastating and far-reaching consequences for hundreds of thousands of American families affected by the opioid crisis, ends in a criminal conviction. Alexis Playas, who lost a son to an opioid overdose, was standing outside the courthouse when the sentence was handed down. She said she felt some measure of relief, but no sense of justice. Since 1999, the opioid crisis has been linked to more than 900,000 deaths in the United States. Approximately 230,000 of them were caused directly by prescription opioids, including OxyContin. In 2017, more than 191 million opioid prescriptions were issued to Americans in pain. 80% of people who develop a heroin addiction first abused a prescription opioid. The annual economic cost of the epidemic in healthcare, treatment, lost productivity, and the criminal justice system is estimated at $78.5 billion. In nearly half of all cases, the addiction began with a prescription. McKinsey and Company, which designed the marketing strategies that accelerated this process, reached a settlement with attorneys general from 47 states in 2021, paying $537 million and agreeing not to work with certain narcotic manufacturers. The firm admitted no wrongdoing. More than 2,600 federal and state lawsuits have been filed against Purdue since 2007. The Sackler name has been removed from virtually every institution that had accepted it. Tufts University, Yale, NYU, the Met, the Guggenheim, the Smithsonian. The erasure was systematic. The donations that built that legacy were not returned. What remains when you look at this case in its entirety is not just the magnitude of the crime. It is the architecture of impunity. Every piece was built with intent. Science captured to create a safety narrative. Doctors converted into distributors. Regulators neutralized or recruited. Medical software weaponized as a marketing channel. Money transferred into untouchable structures before the lawsuits arrived. And when the legal system finally closed in, the family had already prepared its exit mechanism. Bankruptcy as a shield, negotiation as a substitute for accountability. Purdue Pharma was not a case of isolated bad faith in a good faith industry. It was a demonstration of what is possible when a private corporation has enough capital to capture every layer of the system designed to regulate it. The Sacklers understood something most people prefer not to admit: that in a market democracy, the power of a sufficiently wealthy corporation finds no break in institutions. It finds only the price of institutions. Every generation has its own monopolies. The names change. The mechanism does not. If you want to keep understanding how that mechanism works, how corporate power captures systems, buys legitimacy, and escapes consequences, subscribe to the channel. Each episode is one piece of that same puzzle. Hit like if this story surprised you, and tell me in the comments, which company today do you think is doing the same thing?